Good afternoon and welcome to today's NHLBI Small Biz Hangout, Making Your Mark, the Use and Care of Trademarks. My name is Eric Padmore. I am a scientific program analyst at the National Heart, Lung, and Blood Institute, and I will be your moderator for today's event. The NHLBI Small Biz Hangouts are being developed by the Office of Translational Alliances and Coordination as a resource for biomedical innovators to gain access to plain language explanations of the types of business expertise that they did not learn in medical or graduate school. The series includes presentations to describe the basic concepts of regulatory, business, and intellectual property development that accompany the scientific development of technologies. All of the Hangouts are available on the NHLBI YouTube channel. These events are intended to be interactive, so please ask questions. We want to hear from you, and we'll pause periodically to address your questions. There are three ways, which you can see here, which you can ask questions during the event. Via email at nhlbir_sbir@mail.nih.gov, using the hashtag SBIRchat, or direct message to us via our Twitter feed at NHLBI_SBIR. If you would like a copy of today's slide deck, please go to the link shown here at http://bit.ly, that's bit.ly/June2015 feedback. Here you will have the opportunity to tell us how we can improve, suggest topics for future events, and submit a request for slides. Now I would like to introduce today's presenters. Dr. Gautam Prakash is an intellectual property attorney with 13+ years of experience on both sides of the IP fence, both submitting to the USPTO and as a patent examiner. Gautam is currently working within the Office of Translational Alliances and Coordination as an intellectual property advisor. While at NHLBI, he is available to provide non-binding advice to our biomedical innovators and to help them understand the IP landscape for their innovations. Mr. James Menker is a trademark attorney with over 20 years of experience working within the USPTO and for both large and smaller boutique law firms. He is a principal at Hawley & Menker, a firm that he co-founded in 2008. At this time, I am pleased to hand over the presentation to Dr. Gautam Prakash. Gautam?
Thanks, Eric, for that introduction. The only thing I'll add before we get started is that Jim is not only a trademark expert today, but he's also a friend for over a decade and an ex-colleague. To recap, we did an intellectual property basics webinar on April 14th, in which we introduced the major forms of intellectual property protection, which is patents, trade secrets, trademarks, and copyright. I provided a brief overview of the patent and trademark examination process and the copyright registration process. We also discussed the portfolio considerations, and I provide the archive links for that webinar here. Today, what we're going to do is we're going to focus specifically on trademarks. So, the objectives of this webinar are to understand the different types of trademarks, how to select and adopt the trademarks. We'll look more in detail at the trademark registration process at the United States Patent and Trademark Office, how to properly use and not misuse trademarks, and we'll again revisit these trademark portfolio considerations, but in more detail this time. And now for the obligatory disclaimer. This presentation is for educational purposes only, and it's definitely not meant to provide legal advice. All the views expressed are solely those of the presenters, that's Jim and myself, and do not represent the views of the National Heart, Lung, and Blood Institute, the National Institutes of Health, the Department of Health and Human Services, the U.S. government, and of Hawley & Menker. Okay, so most of us in the audience are probably wondering what the reason for this webinar is, and in particular, having known about patents and why to get them, some might be wondering why a company should expend time and money both of which are scarce resources in a small company to obtain one or more trademarks. Well, the most important reason is that trademarks help customers find your product and distinguish it from your competitors. You've all started small businesses because you're in the market for trying to create products and services and sell them to customers. So it's important that your product or service is distinguished from your competitor's product or service, and trademarks help you do that. Now, we all know that patent rights expire, but trademark rights do not. So as long as the trademark continues to be in use, you can continue getting intellectual property rights through your trademark. And trademarks can help you maintain exclusivity and market share even after the patent rights have expired. So one example is isobutyl phenylpropanoic acid, which was patented in 1961 and is now clearly off patent. Now, most of you know this compound as ibuprofen, and there are many companies still selling this off-patent product, as we all know, and maintaining some level of exclusivity using trademarks, some which I've shown here: Advil, Midol, Motrin, and so on. So with this background piece over, and hopefully having convinced you that trademarks are worth getting, I'm going to turn the presentation over to our expert, Jim Menker. Jim?
Thank you, Gautam. Thank you, Eric, for the introduction. I'd like to thank the National Heart, Lung, and Blood Institute for inviting me here today, and I look forward to talking about trademarks. Feel free to ask questions as we go along, and we'll answer them as best we can. First thing to think about is, what is a trademark? A trademark or service mark includes any word, name, symbol, device, or combination of those used to identify and distinguish the goods or services of one enterprise and distinguish them from another. The way to think about trademarks is the trademark is your brand identity. It is the marketing sweat equity that you put into getting consumers to recognize you as the source of your product and your source as being unique and distinct from other companies. A trademark represents the goodwill associated with the trademark, and it goes back to Roman and even Egyptian times to indicate who the manufacturer of a particular product was. In the old days, in case something went wrong, but in today's world, hopefully it's for something that goes right. A trademark is almost anything that is capable of carrying meaning. The best way, I think, to get a grasp of what can constitute a trademark is to look at different categories of trademarks that are being protected today. I think we're all familiar with words and designs serving as trademarks. One of the most common trademarks is, of course, the name of whatever your product is or your company. Oracle, for instance, is a trademark for computer systems. A well-recognized design is the Apple logo with the bite taken out of it. That's recognized as indicating the source of phones and MP3 players and computers and quite a few other, and now watches. Some less traditional trademarks that are protected are colors and sounds. One of the most well-known color marks is the robin egg blue color that is associated with Tiffany and Company. Pink is also a color used for insulation that is recognized, long been recognized as a trademark. Sounds, for instance, you might be familiar with the sound that accompanies Intel Inside. I won't sing it because I'm pitch deaf, but I'm sure you know it by heart. The sound that NBC uses to indicate that they are the source of their television broadcasting. Those have been around for a long time. They are well known, but there's other types of trademarks also that are non-traditional trademarks, but also easily protected and can help distinguish one product from another. One example is scents. Tactile marks is something that has a feel to it. Taste and motion marks. A good example of a scent mark is the scent of bubblegum for athletic shoes. Likewise, a tactile mark is a wooden bark texture used in connection with a wine bottle. So go, and even if you're looking in the dark and you feel the wooden bark texture of their bottle, you'll know exactly the source of that company. A trademark indicates the source, and even if the source may not be immediately known to you, the trademark will actually stand out, and in the absence of other context, will indicate the source. One interesting trademark is taste. It's not always applicable because we don't always taste our products, but some can be tasted. And the flavor of peppermint for nitroglycerin is an example of a trademark that's being protected for nitroglycerin. Another non-traditional mark is motion marks. One good example of this is the searchlight feature that is used by 20th Century Fox at the beginning of their movies, and those searchlights, even in the absence of the 20th Century Fox sign, would be an indication of the source of those movies. One last category to think about is actually kind of a broad category, and that's trade dress. That includes your product packaging and product configuration. Product packaging would be something like a Coca-Cola bottle. Even without the Coca-Cola word on the bottle, you see the bottle, it has a distinctive shape, or an Avion bottle also has a distinctive shape, and these are service trademarks. A product configuration is a little bit more difficult to protect, but they certainly can serve as trademarks. The shape of a goldfish for crackers is a protected trademark, as is the grill for a Rolls-Royce. Ferrari auto body is also protected as a trade dress.
Wow, Jim. When you said that almost anything can be protected by a trademark, you weren't kidding. So I've heard people say things like this is a strong trademark, like Coca-Cola, or this trademark is weak. What does it mean to have a strong or a weak mark?
Well, trademarks are can be thought of along a spectrum of distinctiveness. There's a taxonomy that's used to characterize trademarks. These are pinpoints on a broad spectrum, and they range anywhere from arbitrary and fanciful marks on the one end to generic terms on the other end. An arbitrary term is a term that is in common parlance. For instance, apple is something that we know describes a particular fruit, but when it's used in connection with computers, it becomes an arbitrary term. Amazon, for instance, used in connection with online retail store services. There's no connection between Amazon and the company or the products or services that they provide, and so it's an arbitrary mark. A fanciful mark also is a very strong trademark. A fanciful mark, unlike a arbitrary mark, is one that is a coined term. It's a term that has no dictionary meaning, has no meaning before the trademark is adopted, and a good example of that is Kodak. Kodak for cameras is a long-standing and well-known trademark. Moving down the ladder towards the midpoint, we have suggestive marks. A suggestive mark tells consumers something general about a product or service without being specific or immediately telling consumers anything about the product with a degree of particularity. In other words, it's the information that it gives is indirect and vague. And this would contrast with descriptive marks. Now, there is no clean boundary separating suggestive marks from descriptive marks. Rather, a mark or a combination of terms is going to fall somewhere depending on the usage, context, etymology, connotation, syntax, meaning, and other factors that are relevant to the public perception of those terms. A term or terms may possess elements of suggestiveness and descriptiveness at the same time. It's not fatal for trademarks to be informational. One may be informed by suggestion as well as by description. To think about suggestive marks is important to consider that it's something that requires imagination, thought, or perception to reach a conclusion about the goods. By contrast, a descriptive mark immediately conveys information to the ultimate consumers concerning a significant quality, characteristic, function, ingredient, attribute, or feature of the product or service in connection with which the mark is used. There's a public policy reason for that. That is, we want to keep words available for consumers for other competitors to use to describe their products. A generic term is something that the relevant public understands primarily as referring to the category or class of the goods or services. Put another way, a generic term is one that refers to the genus of which the particular product is a species. Generic terms are by definition incapable of indicating a particular source of the goods and cannot be registered as trademarks. Doing so would grant the owner a monopoly since the competitor would not be able to describe his goods. So just spending a little bit more time on what these categories means. An arbitrary or fanciful mark is registrable. A generic term is never registrable, but a suggestive or descriptive mark, a suggestive mark is registrable, of course, but a descriptive mark may be registered, but only upon a showing a secondary meaning. Now, there's several artifices that can be used in creating trademarks. For instance, you might misspell a trademark or use hyphenation, but those typically do not have transform a descriptive mark into a suggestive mark. If you combine terms or telescope terms, that may not be sufficient. It normally is not sufficient to change a descriptive mark to a suggestive mark if those terms are descriptive and when combined and don't create a transformative meaning. The addition of a definitive article is not something that changes a trademark, a descriptive term to a suggestive mark. For instance, if I say the Sharp TV, that the use of the does not change the commercial impression of the mark. Sometimes double entendre will be transformative if both of the meanings are not descriptive. For instance, sugar and spice evokes memories of a popular song way back, and for bakery products that would not be a descriptive mark. Likewise, repeating terms would not be a transform a descriptive mark into a suggestive mark. So those are all sort of dynamics that go into determining whether a mark is either descriptive or suggestive. And descriptive marks, I should point out, include surnames and geographic terms. Those terms would be considered descriptive. Now, trademarks are not static. They can become generic. They can start life as an arbitrary or even fanciful term, and over time, through use and misuse by the public, they can become generic. There's some very popular examples of that. Aspirin, escalator, and laundromat all started life as coined terms and later became the generic terms for those products.
Okay, so here I have set out a hypothetical product for an Ebola test device that I'm thinking of developing. Here's some of the characteristics. The user draws blood sample and puts it in the device for analysis. The device determines the presence or absence of several factors and transmits the data to a central office. The central office analyzes the data from the device and transmits a code back to it, which causes it to change color. The shape, the device is shaped like an elephant, and the device needs a name. So to help us out, I've set out the taxonomy or hierarchy of trademark types, and the first name I have is Ebola test.
Well, Ebola test seems to describe the product more as a general name for the product rather than serving to indicate source. So I think Ebola test would fall as a generic mark.
Okay, so Ebola test is a generic term. How about a clearly non-generic mark, such as sailboat?
Well, sailboat doesn't seem to have any meaning as applied to your Ebola tests. On the other hand, so I think it would fall as a arbitrary trademark and would be very strong to start life. However, it would be difficult, I think, for you to use sailboat in connection with your product and start marketing it because consumers would have no idea what your product was when they encounter that trademark. So you might want to think of something that helps inform the consumers something about the product you want to sell.
Okay, so even though arbitrary or fanciful marks are strong trademarks, they may not be the best kind of trademarks to have. Okay, how about Ebola quick? One word, capital Q in the middle, and quick misspelled as Q-U-I-K.
Well, I think that absolutely falls somewhere in the range between descriptive and suggestive. It has some elements to it that could describe your product, but it also could be somewhat nebulous as to what is quick about your particular product. So I think maybe that's the best one to go forward with at this point. What do you think?
So Ebola quick looks like a good mark for our product. Jim, I just wanted to clarify, it doesn't matter then that the word quick is misspelled and that it's fused to the word Ebola, and that doesn't help us as to whether the mark is descriptive versus suggestive.
Yep, that's correct. The terms that you're using have not changed the meaning by combining them. They are still a reference to the purpose of your product, and that is something about Ebola. And Quick in itself is not being used in a way that adds anything to Ebola to change the overall commercial impression of Ebola and Quick if they were separate terms.
Great. Now that we have selected a possible mark, and before we look into how we can clear it, register it, and adopt it, let's just pause and see if any questions have come in. And actually, a question has come in. So we talked about the shape of the product, and if you remember, it's elephant shape. Does that help us? Does that make any difference in terms of the continuum of trademarks and that it falls into?
Yep. Well, if the product is not testing for Ebola in elephants, then I would say that is a arbitrary configuration of your product. I would not think that consumers would need, or any other competitors would need to use the elephant shape for their product in order to be able to compete in the marketplace. And I think the only thing that would cut against finding that is an arbitrary mark is if an elephant shape was somehow functional in terms of how your product performed its functions. And I don't think that would be the case, but that would be something that we would have to talk about.
Right. Thanks, Jim. So another characteristic and question that came in of our product is the color. Does the fact that it has a particular color or it changes colors or any of that, does that make a difference in terms of registering the product?
Yep, a color can be a trademark. Normally a single color, or always a single color, for any product is considered descriptive to start life. You would have to use it over time and look for advertising, and over time that could acquire distinctiveness in the marketplace. Sometimes multiple colors are inherently distinctive, and so it may be that if you did a pink and purple elephant, that could be a inherently distinctive trademark, a suggestive or arbitrary mark.
Okay, Jim, thanks. So another question has come in about service marks, and if you'll notice, if you remember in our product, we have both a actual product and a service. So can the same trademark Ebola Quick be used for both the product and the service?
Absolutely, a trademark can be used for multiple goods and services.
Excellent. These are great questions. I thank you all for sending them in, and you'll have another opportunity to have questions for Jim. So, Jim, now that we have selected a possible trademark, can you give us a sense of what happens next?
Okay, trademarks are unlike patents that your rights come at the time of issuance. Trademark is granted on a first-come, first-served basis. You can be the first to use the trademark in the marketplace in connection with that particular product or products or service, or you can file an intent-to-use application with the United States Patent and Trademark Office. There is always a risk that somebody else might have already obtained rights to an identical or similar trademark in the same market. And one of the best ways to find that out is to conduct a search to determine whether or not there are other rights. There's no legal duty to conduct a search before commencing use. However, that's the primary means that you have at your disposal to assess the risk. If you fail to do the search and you invest quite a bit of money into your trademark, into marketing your product, you can run into considerable trouble. If somebody has earlier rights, they could send you a cease and desist letter. They could just file suit against you seeking injunction and damages. And even if you don't want to engage in a dialogue or exchange of letters with the other party, you'll likely have to come up with a new trademark and start the process over again.
Okay, great. Okay, we've searched the existing trademarks. And it looks like a search is a good idea. Can you give us some options on how to conduct such a search? It seems like search is something we need to do.
Yep. Conducting searches is actually fairly easy. The United States Patent and Trademark Office has a searchable database of all registered and pending trademarks, as well as all canceled and expired and abandoned trademarks. So you have a complete list of the records. You can do what's called a knockout search. You can use the Trademark Office electronic search system test, and I've given you the link here, and that allows you to search using Boolean logic to find any trademarks that might be relevant to what you're doing. So you can go on there on the Trademark Office website. It's a free service, and you can determine whether or not anybody already has some marks. So that's the first place to start. If that comes back fairly clean, then you can proceed to do a comprehensive search. Usually these are conducted by professional search companies. They're searching not just the Trademark Office database, but also state trademark databases and common law databases that are looking in proprietary databases and the internet and domain names and everything else they can think of to find out whether somebody else is already using the mark. As we talked about, trademarks rights stem from use and not necessarily registration. So there may be people using a similar mark without having filed an application to do that, and they could come and stop you from using your trademark if they have earlier rights. Comprehensive searches usually run in the neighborhood of $400 to $600, depending on the company that provides those. They tend to be about 400 or 500 pages long, or 200 pages long, with about 400 or 500 references. But I think what we'll do, in addition, if you have a trademark that you plan to use in connection with a product that is governed by the FDA, they have to approve it as well. They will reject any sort of trademark that promises results. For instance, I think happiness for antidepressant would be rejected by the FDA.
Excellent. So, Jim, I think in advance of this presentation, you conducted a search of Ebola Quick, the way it's written out, in tests, and you have some screenshots. So maybe we can look at the results, and you can explain to our audience how you conducted the search. And this goes back to the question that came in, which is how do I find registered trademarks that might be similar to mine?
Sure. And the first thing I did was I did a search for Ebola and Quick together, and nothing came back. So then the next step I did was to look at all the Ebola marks that are out there. So I did a search of Ebola and then truncated it there in case somebody changed the last letter of the vowel in the name. So this is the results that came back for active records that have Ebola in it. You can go into each one of these records and look at the goods and services, the company that filed the application or owns the registration, all the information about how they use the mark. There's examples of the specimen they use that we'll talk about later that they've submitted to the Trademark Office in order to get their trademark registration. So here's all the Ebola marks, and then we did a search for Quick marks. Of course, there were hundreds and hundreds and hundreds of Quick marks, but we were able to narrow it down by looking at just Quick marks that were registered for tests in the medical field. So Class 10 is medical devices, and test describes the goods or services that would be found in the relevant records. And here are the ones that came back with Quick as a part of the trademark, and test and medical devices as the product category. So,
Jim, we're doing well on time, so I would like to actually look at some of the syntax you used here, because it is kind of interesting. Two things I wanted to ask you. The first one is, I noticed that you searched the word Q-U-I-C-K, even though the Ebola mark is spelled as Q-U-I-K, and so maybe you can. You already talked about the 010 class for goods, but maybe you can just give us a brief idea of what BI and TI is and why you search those two and what those mean.
Sure. As we talked about earlier, a misspelling of a trademark does not transform it from a descriptive term to a suggestive term in most cases. And the Trademark Office, when you file your application, they look at all trademarks and they come up with pseudonyms for any of the terms within your mark. So any mark that we would file for QUIK, would be coded in their system as QICK, and that would be the translation index, the TI there. So the basic index is the way it's entered into the Trademark Office database, and the translation index are not just foreign equivalents if you have a foreign term, but also pseudomarks is what they call them.
Excellent. So it's good to know that there's a way to search for misspellings and foreign words. That's great. Okay. We in the earlier presentation on IP Basics, we talked about registering a trademark, not just obtaining it, searching it, but registering it. And Jim, you're the expert. Maybe you can give us a little more detail about why I should go through the time and effort, especially as a small company, to register my trademark.
So trademark registration stems from, your trademark rights stem from the use of the trademark, not from the registration. Registration is a confirmation of your rights, and that differs from a patent where your patent rights stem from the issuance of a patent in the claims within that patent. So your use, it governs your rights, and so the trademark registration system is optional. However, there are quite a few benefits to registering your trademark. It provides notice to others of your trademark rights. As we just looked in the Trademark Office database for earlier marks, that's where we started our search. So if we had applied to register a bullet quick, that would show up in there, and that would put others on notice that, hey, somebody's already out there claiming rights in this, perhaps we should choose a different trademark. You also, as we talked about, it's one of the ways to get rights before you start using it. So if you file an intent to use application with the Trademark Office, your rights will date back to the date that you filed the application. So if your product's not ready for market, it's not ready to be sold or transported in interstate commerce, you can file that intent to use application. Your rights will go from there, and then you can have some degree of certainty that you won't have to worry about intervening rights between when you decide upon the name and when you start using it in commerce. A trademark registration also gives you the presumption of validity. So in other words, if you have a trademark registration on the principal register, that's going to be presumed to be at least a suggestive mark, if not an arbitrary or fanciful mark. You won't have to worry about it being challenged as being descriptive unless somebody can show with conclusive evidence that that's the case. Your ownership of the trademark is presumed, as well as nationwide rights. So you might start off using your trademark only in the Northeast United States, but your rights from a trademark registration will allow you to use it throughout the United States. One of the most important benefits of a trademark registration is that after 5 years of registration, it becomes incontestable. Incontestable doesn't mean that it can't be challenged, but the number of grounds upon which it can be challenged and canceled are very limited. Nobody can come and claim earlier rights at that point. Also, they can't argue that your trademark is descriptive if it was registered on the principal register. That also is important because the only grounds then would be challenging based on genericness. So that's a pretty steep burden for people to prove. The Supreme Court just had a case, a trademark case, a couple months ago, and they were unequivocal in explaining that a trademark registration in the Trademark Act impart important legal benefits and rights on trademark owners who register their marks. So there's definitely some value to registering your mark, and as we'll talk about a little bit later, the cost is not very high for registering trademarks.
So you put up the flow chart of the process for registering a U.S. trademark. Maybe we can just walk us through that.
Sure. So you picked out your trademark. Now you're filing your application to register that trademark. It's going to be examined by the trademark examining attorney at the Trademark Office. They're going to assess whether or not your trademark application is in condition for approval and whether your mark is registrable. So if they determine that it is, your application will be published for opposition. If it's not opposed, you'll proceed to allowance or registration. Now, if you are refused, you'll have an opportunity to argue a refusal, and at that point, even if they maintain that refusal, you can abandon the application or you can appeal your refusal to the Trademark Trial and Appeal Board. If somebody does oppose as well, that's also heard before the Trademark Trial and Appeal Board, and you'll get a decision, inter-parties decision process.
So what does the examiner look for during this examination process?
Yep. The first thing they're looking for is this distinctiveness of the trademark. They're looking at the taxonomy and determining where your trademark falls along that spectrum. If they're going to do some searches on the internet and news articles and try to find out whether others in your field are using that mark in a descriptive sense. They're also going to do searches of the Trademark Office database. So they're not going to search outside the Trademark Office database, only inside. And they're going to see if there's anybody with earlier rights in the same or similar mark. At some point, they're going to look at whatever specimen of use you submit for your trademark. Before you can get a registration, you have to show that you are using it. And the final thing they're going to look at is whether your description of goods or services is definite and describes your products or services in easily understandable terms. If any of these elements are missing, the Trademark Office is going to issue an office action. They're going to explain the reasons for rejecting your trademark application. You get a 6-month response period. That is not extendable. If that doesn't resolve the issue, if your arguments and further evidence don't resolve the refusal, then the Trademark Office can issue a final refusal. Again, you'll have another 6 months to respond to that refusal with arguments and evidence. If that doesn't work at that point, if you don't file an appeal to the Trademark Appellate Appeal Board, it will be your trademark application will be abandoned.
Great. So Jim, we always get these questions: how much and how long? Can you give us an idea of the cost and timelines for getting a trademark registration?
Yep, when you file your trademark application, you have to pay the fee for at least one class. The cost is either $225 or $275. These different price categories are determined by the parameters of your application and not by the size of the entity that applies. The examiner is going to look at your application at about 3 to 4 months after you file. There are no examination fees. There's no fees for filing responses to office actions. There's no extensions that we talked about, so there's no fees for filing extensions. If everything goes smoothly and you get no objections or rejections, no office actions, your application is going to be published for opposition. Again, there's no publication fee, and it starts a 30-day opposition period. And during that opposition period, anybody can, from the general public, can oppose your application by filing a notice of opposition. They can also file an extension of time to file a notice of opposition to extend their personal time period. And in those cases, normally they're asserting earlier rights or that your mark is actually descriptive instead of suggestive. So if everything goes smoothly and you get no office actions and you get no oppositions, the USPTO is going to issue the notice of allowance if you haven't filed your allegation of use. If you already have filed your allegation of use, you're going to get a certificate of registration. But let's say you haven't done so at that point. You're going to have 6 months from the notice of allowance to file your allegation of use and proof of use. There's a $100 fee per class for filing that allegation of use. And if you can't do so in that time period, you can file extensions, and the cost of those are $150 per class. You get 5 of those, which gives you a total of 3 years from the time you get your notice of allowance to prove that you're using the mark. Once you file your allegation of use or you pass through the opposition phase, in about 3 to 4 months after that, you'll get a registration certificate, and your mark will then be registered. There's no fees for issuance or for the certificate.
Excellent. So let's pause again for a couple of question answer session. And actually, a very great question has come in, so I will read it out to you, Jim. For FDA approval of the trademark, when do you do that in the regulatory pathway? In other words, do you have to get approval first for the product itself? Do you do the trademark first? You've had some experience with medical devices and pharmaceuticals. How does a company go about doing this?
Yep, it's a separate process for notifying the FDA of your intended trademark, and they go through the process. You don't have to have filed an application for that. It's completely independent of the Trademark Office's process, and you're doing that along the way, so you don't have to get approval first. You can simply indicate that that's the name of the product that you have a pending application for.
So does that mean that just to be on the safe side, a company will get approval from the Trademark Office for several marks and from the FDA for several marks, and then pick and choose, or how does that work?
Yep. Normally, for pharmaceuticals particularly, pharmaceutical companies will have 3 or 4 trademarks that they have put through the trademark registration process. Again, they're solidifying that priority date, the date that they file those applications, and then they wait for the FDA to approve or disapprove of the trademarks that they've adopted, and then ideally at least one of those is going to come clean through both the trademark office and the FDA process.
Okay, so multiple prongs of attack. Wonderful. That's all we have for now. So let's go back to the presentation. We've gotten our trademark issued. Is there anything else we need to do?
Yep. So as we talked about earlier, trademark lasts forever as long as you're using the trademark. The rights stem from use, so as long as you're using it, you still maintain your rights. But there are certain time periods that the trademark office requires you to establish that you're still using the mark so that your registration will remain valid. The first one comes about at the 6th anniversary of your trademark registration. You have to file what's called a declaration of use with your proof of use, which we'll talk about in a few minutes, and there's a fee for that. After 5 years, we talked about your trademark registration becoming incontestable, and after the 5th year mark, you can file your declaration of incontestability. Normally, you'll combine the first declaration of use and your declaration of incontestability into a single filing. The fees aren't less, but it's a streamlined process for those two since they occur generally at the same time. And then at the 10-year mark, and every 10 years after your date of registration, you can file a renewal application. You file it between the 9th and 10th year, 19th and 20th, 29th and 30th. Between that time period, you file your renewal application, and the cost is currently $400 per class for filing that renewal. As long as you file your renewals, your trademark registration will remain valid. So a renewal application and declaration of use are examined by the trademark office. They're looking for a few things. One of them is that you're the owner of the trademark. If there's any discrepancy between the owner identified in the renewal application and the registration, they inquire about it. You may have to prove that you're the successor in interest. They're checking your proof of use, your specimen of use, to make sure that you're still using the mark as a trademark. And if there is a missing declaration, they'll ask for that. If there is some problem, they issue an office action, and you have 6 months to respond to that. You may be able to correct things if you're still within the time frame for filing the renewal.
So, Jim, it looks like showing that the trademarks continue to be in use are very important. And maybe you can give us some examples of what constitutes proper specimens of use for both goods and services.
Yep. So one of the most difficult concepts for the trademark process is supplying the proof of use. The trademark office isn't looking to see that you've sold the mark, sold the product that you've applied for. What they're looking for is to see that you're using the trademark in a way that's associated with the goods or services. So to determine whether or not that's occurring, they ask you to submit a specimen of use. So examples of specimens for goods are tags and labels, packaging, using the trademark on the actual product itself. As we talked about, because they're not looking to see if you've actually sold it or transported, invoices and bills of lading and shipping documents and incidentals to the business are not going to be accepted. Likewise, if things are just mere advertising, commercials, things like that, are not going to be accepted as proof of use, as your specimen of use. But this contrasts with services. In services, you're looking for advertising of the services, the promotion of the services. Websites, for instance, can service specimens for your service.
Great. Maybe we can talk about proper use and certainly to avoid misuse of trademarks.
Yeah. What we talked about is being so important is your use of a trademark. Your rights are stemming from the use and not from the registration. So what does use of a trademark mean? So a trademark that's used in commerce on goods is placed on the goods or on one of the acceptable types of specimens that we talked about, or display associated with the goods. And the goods are sold or transported in commerce. So you have to have both of those elements. You have to use the mark as a trademark, and then you have to have sold or transported. The trademark office takes your word that you have sold it or transported it in commerce. They don't inquire about that. But if you were challenged, you'd have to show that did occur. The question often comes up: how much use can I sell one to my brother-in-law? Can I send one to my college buddy? Would that be enough? And generally, the rule is it has to be a bona fide use. It has to be consistent with what would be expected for that type of product. it's got to be more than just a mere trickle of sales. It's got to be something substantial. One of the exceptions is the Trademark Act specifically recognizes that samples and test drugs that are sent to clinical investigators during the FDA approval process will be considered use in commerce, even though the product is not technically available.
So before we move on to services, Jim, I have a question come in, which is, what if I only sell one product a year, one of these things, because I'm selling the worldwide? Does that?
And that's and sometimes you'll have products if you sell a aircraft carriers. An aircraft carrier you probably only can make one every 3 or 4 years. So they're looking at what's common for that type of product. If the product is something that it sells for hundreds of thousands of dollars or millions of dollars, you may only be able to manufacture and sell 1 or 2 of those a year. If you have sales that are in the pipeline, like aircraft, for instance, another one that has a very low sales volume on a per item basis, those would still be considered use in commerce, even though your number of sales is not particularly high.
Great. Maybe we can move on to services.
Yep, and so use of a mark for services is slightly different. You have to advertise or sell the services, and then the services have to actually be rendered in commerce. So you have to not only promote them and sell them, but you have to actually perform whatever the services that you.
Great, and let's talk about misuse now.
Yep. So as we talked about earlier, trademark rights can be lost. A term that's arbitrary or suggestive or even danceable can become a generic trademark, and care has to be taken. You want to be as popular as Google and Band-Aid, but you also have to take care that people don't misuse your trademark to the point where you could lose rights. And both of those companies go through great lengths to avoid that happening. So one of the ways you can do that is always use your trademark as a adjective and add the generic name for the product. FICO score, for instance, by adding score to it, then explains that FICO is not a generic term, but the score is a generic term. You don't want to use your trademark as a noun or a verb. Google goes through great lengths, I think, to prevent people from saying Google it. There's only so much they can do, obviously. It's in the common parlance, and unfortunately for them, but they have on their website a page where you can go to, and it tells you what you can and what you can't do with their trademark. And one of them is not to use it as a verb. You shouldn't use your trademark in a plural possessive form, and you don't want to abbreviate or hyphenate your trademark if that's not normally the way in which it's used. So the question often comes up, use of the TM symbol and the circle R symbol, when can I do them, what do they mean? Well, you always can use the TM symbol. You do it immediately upon your actual use. You can even do it before you started using the mark when you're promoting your services. It doesn't mean that you have rights. It doesn't mean that you filed an application. It only means that you're claiming rights, claiming that term or design or whatever the trademark may be as your trademark. You can only use the circle R after you have obtained the federal registration, after you get the certificate. Only then can you start using it. If you use the circle R before you actually had the registration certificate, that could be considered unfair competition, and somebody could sue you and claim damages from your misuse of the federal circle R symbol. You'll always want to use your trademark in a consistent manner. If it's stylized normally, you always want to use it in the same stylization. I think everybody will recognize that Coca-Cola is almost always written as the Coca-Cola script.
Great. So a question has come in about international trademarks, and that was the next piece of the presentation, so I'll go to it now. The question was, how does one get international or global trademark? How do we establish that?
Yep. So your rights are defined by the jurisdiction in which you are using the mark, or in other countries is where you own a trademark registration. So unlike the United States, every other country other than U.S. and Canada only temporarily right now, there's no use requirement. So you have to file your application and obtain a registration, and then you'll have rights in those trademarks. You can do it in 3 ways. You can file a national trademark application. There's group country trademark application mechanisms such as the European Community Trademark, and then we had the Madrid Protocol, which consolidates and minimizes trademark application process in the for national trademarks. And as we talked about, there's no use requirement, so trademarks can be used defensively. In some cases, you may want to file a trademark application in a jurisdiction that you're planning to go to, or you're talking to a potential distributor. You want to file before they do, because what can happen is that your distributor partner that you're talking to, it may be well-meaning at first, but they file an application for your trademark in their country, and then if things go south, they can hold your trademark hostage and prevent you from using your own trademark in their jurisdiction. So sometimes you want to be careful and jump ahead. There's different things to think about for trademarks. You can have a house mark that unifies several different product marks, and then within your different product offerings, you could have the same, or you could have different marks depending on the nature of the product and the nature of the image that you want to convey to people. So Apple's done that. They've used their eye marks as their product marks, and they try to build upon that. I think iWatch now is being assessed for distinctiveness.
Great. So I think we have a little bit more about international trademarks because everybody's concerned about that, it looks like. So maybe we can just talk about that a little bit.
Yep. So as we talked about, trademark rights are territorial. You have to file in each country that you want to have trademark rights in. You can do that within the national trademark application process. You have 6 months from the filing of a U.S. application to file in other countries and claim priority back to the U.S. application. What that means is you get the same effective filing date. So if you file January 1st in the United States, you can file all the way up to July 1st and get that January 1st filing date, and vice versa. Others that are filing abroad can come to the United States and also take advantage of that 6-month priority period. It doesn't mean you can't file trademark applications after the 6 months. There's no bar to filing trademark applications at any point. You can always file. You just won't get that earlier filing date from the U.S. application. There's no use requirements in other countries, so you can be a little bit broader in international filings than you can in your U.S. application, which you're going to have to show use for. One of the best ones is the European Community Trademark. There are a couple others in Africa that are also multi-nation trademark applications, but the European Community Trademark application covers 28 countries. There's just one application, and you get this one examination, one opposition period, and you get one certificate of registration. So you can cover quite a bit of countries for a fairly reasonable cost in those, in the European Union. Then you have the Madrid Protocol. That is a streamlining filings in up to 92 countries. You can use a menu to select the countries that you want to extend your U.S. registration to. So you have a U.S. application or registration, you file a separate Madrid Protocol requesting an extension of that U.S. registration to all these different countries, and they go through examination in each different country, and you can have issues in each country that you have to address during the examination process. But it does streamline the filing, and also when you get time for renewals, you can do it all at once.
Great, thanks, Jim. You put together some trademark resources here, which I've listed out. They all look pretty straightforward. The only one that maybe requires a little bit of discussion from you maybe is this ID manual. What is that?
Yep, so the USPTO has put together a list of, it's a searchable database of all approved descriptions of goods and services. You can describe your goods and services differently than what's in the ID manual, but the ID manual are all approved. And if you recall, when we talked about the different filing fees, one of the main parameters for qualifying for the lower filing fee is that your specification of goods and services comes from the USPTO's ID manual. So if you can find something that is accurate in describing your product and it's in the ID manual, you can save some money on your filing fees.
Great. Thanks, Jim. So this is a little bit of information about how to contact us. We have just a few minutes for questions and answers, and one question that's come in, actually two actually. The first one is, you talked about filing intent to use applications, even though you haven't yet have a product. The question is, can you file a whole bunch of intent to use applications and essentially squat on trademarks that you have no intention of using?
Well, you could certainly file the applications. The question is whether or not you would actually have any rights in those marks as filed. You can't sue anybody based on an intent to use application. You have to actually start using the mark first before you can sue somebody. So you can file a raft of applications, but one of the things that that presents a problem for is whether or not you had a bona fide intent to use all the trademarks in the various applications. And so somebody could, if you were to assert those rights or somebody were to challenge whether you had a bona fide intent, one of the things they look to determine whether you have a bona fide intent to use a given mark or a group of marks is if you filed a number of applications for the same product or service. So if you file 10 applications for 10 marks for the same product, that would be viewed as evidence that you don't actually have a bona fide intent to use that mark. And so you could certainly be challenged on that ground. You also have to have documentary evidence supporting that you had a bona fide intent. You can't just the filing of the application itself does not constitute evidence of your bona fide intent. You need a business plan. You have to have some sort of evidence that you actually plan to use that mark, and you have the capability of producing those products.
Okay, and then the other question is, you searched. Thank you for the screenshots of tests and how to search. That was for word marks. But you did mention there's such things as colors and scents and symbols and so on. So the question is, how do I search for non-word marks in tests?
Yep. And so, as we talked about with the pseudo marks, the misspelling of marks, the Trademark Office also maintains a coding for each non-verbal mark. So they're all coded with both a description of the mark and also with a specific design code. They've categorized all designs into one of 26 different categories of designs, and they're given individual design codes. There's a manual on the Trademark Office website that has a searchable database of the different design codes that they use, and you can search their database with designs.
Excellent. Well, great. Thank you for all those who tuned in, and it just remains for me to thank Jim Menker for generously devoting his time, sharing his considerable expertise during his presentation, which I hope all of you, as I did, found interesting, entertaining, and educational. Thanks, Jim. Thanks for all your help here.
Thank you.
I will now turn it back to Eric for some concluding remarks.
Thank you, Gautam. And on behalf of the Office of Translational Alliances and Coordination here at the NHLBI, I want to thank our presenters, especially Mr. James Menker of Hawley & Menker and Dr. Gautam Prakash. Our next Hangout will be on July 14th at 2 p.m. Eastern Time. During this Hangout, we will talk about the Target Product Profile, or TPP, a tool which is used by many biomedical innovators to describe the characteristics of their ideal product and to record how and why their eventual product diverges from the ideal. The TPP is useful at very early stages in product development to outline the information similar technologies have presented to the FDA to gain marketing approval or clearance. This early comparative approach can inform the type and extent of preclinical and manufacturing work to get first-in-human exposure, as well as the extent of human data used to obtain specific label claims. As a new technology advances through its product development and launch, the TPP is used to define, stage, and allocate resources to different aspects of product development work, to frame discussions with stakeholder groups, and to track regulatory interactions and milestones. So please join us again on July 14th at 2 o'clock Eastern Time. Remember, if you would like a copy of today's slides, which contains the information that Jim presented, you can find that at the bit.ly address June 2015 feedback. That's http:// bit.ly/June 2015 feedback. Thank you. And again, the Small Business Hangouts are organized and presented by the National Heart, Lung, and Blood Institute, Office of Translational Alliance and Coordination. If you are developing a product or technology within the NHLBI mission space, cardiovascular, pulmonary, hematologic, or sleep disorders, contact us through our website at www.nhlbi.nih.gov NHLBI/SBIR for additional assistance. If you are developing a product or technology outside of NHLBI's mission space, we encourage you to reach out to a program official in the appropriate institute at NIH for additional assistance. A list of the SBIR STTR contacts can be found at https://sbir.nih.gov/engage/IC-contacts. If you want to know more about upcoming Hangouts, NHLBI small business funding opportunities, or other activities and resources available through our office, please check our webpage, follow us on Twitter, or sign up for our listserv. Thanks again for listening, and have a great day.